and thank you for joining us for this webinar on the impact of the Energy Charter Treaty Agreement in Principle on Climate Policy. This is the second in a series of webinars co-hosted by International Institute for Sustainable Development, the Center for International Environmental Law, and Client Earth. My name is Suzy Nikiema, and I'm the lead of the Sustainable Investment Workstream at IASD. Before we start, let me share some housekeeping rules. Please feel free to use the rename function so that your screen name shows your name and your affiliation. Also, a kind reminder that this is a public webinar and the recording of this session will be made publicly available afterwards. And finally, if you would like to ask a question at any point during the webinar, please type it in the Q&A box and we will do our best to address it. Before setting the scene with some introductory remarks of the modernization of the Energy Charter Treaty and on why our discussion today is so timely, I understand that our keynote speaker, Lisa Sachs, has some time constraints, and we will therefore start with her keynote address right away. Lisa is the director of the Columbia Center for Sustainable Investment and an adjunct associate professor of international and public affairs at Columbia University, New York. Since joining CCSI in 2018, Lisa has established and overseen a robust research portfolio in the center cross-cutting areas of expertise, and has also taken a keen interest in the Energy Charter Treaty modernization from the outset. We are delighted to have her speak today about the bigger picture of the ECT modernization negotiations. Lisa, thank you so much for joining us today, and the floor is yours.
Thank you so much, Suzy. By the way, I wish it feels like it's 2018 sometimes, but I've been here since 2008, my whole lifetime here at the center. So it's always a pleasure to be among these friends, and so grateful to IASD, to CL, to Client Earth for continuing to educate all of us and to foster the critical discussion on this really important topic. So I'm so sorry to not be able to stay for the rich discussion, but I will definitely be watching the recording. I'm joining you from New York, where we are in the middle of both Climate Week and the UN General Assembly, and the conversations that we've had here this week among scientists, among food producers and consumers, among energy and other companies, among policymakers and civil society, really, to me, have set a profound backdrop for this wonderful event. And more fundamentally, for the ongoing public debate in the EU around investment policy, including the Energy Charter Treaty. We are in an exceptionally dynamic moment in our world right now, and we need the clarity of vision to understand and to implement the transformative policies and practices to navigate this period of profound change and urgent change. The whole design and governance of the global economy is fundamentally contested right now. This has been a repeated theme this week here in New York. We are facing urgent global challenges, the climate crisis, the urgency of mass decarbonization, of land use, deforestation and biodiversity loss, and other environmental crises. We are facing social crises of poverty and food insecurity and mass inequality. We're facing geopolitical tensions, which are exacerbated by the competition over global supply chains for critical commodities. And our current economic system and the rules that govern our economic system are not working. The rules that we have are not fit for purpose. Arguably, they were never fit for purpose, as they were never oriented around sustainable development and human rights. That has now been proven over and over again. The investment regime that we have is fundamentally not working. And worse than that, it is hostile to our global goals and to our global investment agenda. We have an entire system of global economic governance, more than 3,000 investment treaties that are based on assumptions that additional legal protections and privileges for investors will spur more investment, and that investment will result in development. That's faulty design built on wrong assumptions, or assumptions that have not panned out, at least. We have study upon meta-study that fail to show that investment treaties have resulted in the increased investment flows expected. We have long studied the drivers of investment, the locational determinants, and we're learning more and more every day about the challenges in allocating capital in key regions and key sectors for sustainable development and the energy transition, and how to address the financial and regulatory barriers that impede that investment. But treaties and ISDS are conspicuously not among those factors. And we don't need studies to remind us that not all investment is good, that the benefits of investment depend entirely on the type of investment, the practices of investors, and especially on how investment is governed, none of which is accounted for in the current investment regime. To the contrary, sustainable development, including the climate crisis, is an investment. So that's where we are, in my view, with the Energy Charter Treaty. This is not a treaty worth saving. It is built on outdated and unproven assumptions to address perceived challenges from 30 years ago, and it is absolutely hostile to the global climate agenda. What has been proposed in terms of modernization doesn't even touch those deficiencies. So this is my invitation. I hope to work with many of you on the regulatory architecture that can guide our global agenda, including rapid and mass decarbonization and a scale up of clean energy infrastructure and investment. It's an urgent mandate, and it's one that deserves our collective ideas. And though I'm joining you from New York in the US, if there is any region in the world that can lead this sophisticated planning, it's the EU. The EU understands the importance of planning, of aligning regulatory frameworks with those plans. The EU can and should unequivocally explain to its treaty partners that the Energy Charter Treaty is beyond repair, that it is an outdated and misconceived treaty, that it is absolutely hostile to the EU's and the world's climate goals. And then the EU should lead in the design of a functional and productive investment regime that indeed addresses the barriers we're facing and mobilizes investment that supports our global goals. So I, again, am thrilled that our organizers are convening these critical discussions to advance that agenda, and I look forward to joining you for many more of them. Thank you very much.
Thank you very much, Lisa, for giving us the big picture about the implication of the ECT modernization process within this global issue regarding the investment treaties. Very rich and insightful reflection that will certainly feed our discussions today. And thank you again for making the time to join us despite your busy schedule. Thank you very much. It's my turn now to share some brief introductory remarks before we move to the first panel of the discussion. And I think following what Lisa just excellently put on the table, it is clear that we are in a decisive decade to avoid the worst climate impacts. And last week, as some of you have noticed it, the World Health Organization, together with 200 health associations, made an unprecedented call for a global fossil fuel non-proliferation treaty. At the same time, and in a striking contrast to this development, the Energy Charter Treaty continues to draw strong criticism from civil society and climate policymakers. Only last month, the ECT was in headlines again when an ECT-based arbitral tribunal ordered Italy to pay 119 million euro plus interest to a UK oil investor because the country's ban of offshore oil exploration had breached international obligation, as they are claiming. Initially designed, as Lisa just said, in a period where sustainable development was not at the core of the discussion, with a view to enable multilateral cooperation in the energy sector, the Energy Charter Treaty is the investment treaty that has generated the highest number of such investor state arbitrations, and which lead to record-breaking damages, however, that have cost governments hundreds of millions of euros. This criticism is no longer limited to the sometimes academic and technical confines of international investment law, but has reached the arena of mainstream climate policy. In the report of its third working group on climate change mitigation, published in April this year, the IPCC recognized the risks generated by the ECT and emphasized that it can be used by fossil fuel investors to water down or to threaten climate policy measures of sovereign states. Amid widespread recognition that the ECT is outdated, and Lisa already pointed that, and constitute an obstacle to the transition to a low carbon economy, the Treaties contracting parties started negotiation to reform the treaty in 2000. The agreed list of topics for the negotiation was limited from the outset and notably excluded a reform of the highly problematic investor state dispute settlement mechanism and the sunset clause of the treaty. And on June 24 this year, the negotiation culminated in a tentative agreement in principle, the text of which was leaked last week, to be voted upon at an Energy Charter conference on 22 of November. Everything points to this date being a high stakes moment, and we expect a specialist in capital, member state capital, currently working day and night to assess whether the negotiation outcome is sufficient to justify an adoption, right? That said, confidence that the reform process can yield the required results is far from strong and unanimous. After, for example, an early withdrawal by Italy, Poland has recently taken legislative steps to unilaterally withdraw from the treaty. Other EU member states, such as France and Spain, have indicated a preference for withdrawal if the negotiations fails to align the treaty with a climate commitment. It is therefore timely to commence a discussion about the implication of the leaked agreement and how it compares to the possibility of a coordinated withdrawal of contracting parties. And this is what we're aiming to do today with two panels of distinguished experts from various backgrounds. Looking forward to a rich discussion, I will now hand over the floor to Amandine van den Berger, who is a lawyer for trade and environment at Client Earth, to introduce our first panelist and moderate the discussions. Amandine, over to you.
Thank you very much, Suzy, and hello, everyone. Thank you all for joining. I think it's going to be a very interesting discussion today, and we are very happy that so many people also joined this event. Thank you very much to Lisa, who unfortunately had to leave the meeting already, but it was a really great keynote speech. I think it really, together with Suzy, set really the scene for our first panel that I have the privilege to moderate. And we have today with us legal and policy experts with whom we are going to discuss the details of the implications of the new ECT text, notably the policy and the legal implications. And I would like to welcome, first of all, Professor Christina Eckes from the University of Amsterdam. We also have Nikki Reich from the Center of International Environmental Law. We have also Kayla Tienara from the Queen's University and Lucas Schog from the International Institute for Sustainable Development. So we will go first for a quick tour de table. I have a few questions for each of us, and that I think are great to initiate the discussion afterwards with the audience. I would ask kindly to keep your remarks to 5 minutes, and you will have time, obviously, to react to each other after. And I will turn first to you, Kayla. Hello, Kayla. You are the Canada Research Chair in Economy and Environment. You are assistant professors at the Queen's University, and you are an interdisciplinary social scientist who studies the intersection between environmental governance and the global economy. And my question to you, Kayla, is that the ECT has been very much criticized for affording protection to the fossil fuel industry and for providing a legal basis for claims against climate action. And the new ECT now includes a possibility for the members to actually exclude fossil fuel from its protection and from the scope. So do you think that it is sufficient for the states to actually avoid being their climate policies and measures challenged in front of arbitral tribunal?
Well, thank you for that question, Amandine. Thank you also to everyone involved in organizing this session. It's really great, and it's awesome to be on a panel of such impressive experts. So the simple answer to your question is no, absolutely not. The fossil fuel carve-out is, in my opinion, too little and too late. I'm going to address that in reverse order. So starting with the too late side of it. So we have just a little over 7 years remaining in what is, I think, universally accepted to be the most critical decade for climate action. So the clock is very much ticking. And we really know what needs to be done in this period. So last year, the International Energy Agency, the IEA, released a very important report outlining that an energy transition pathway that would keep us below 1.5 degrees Celsius of warming involved no new oil, gas, or coal developments as of January 2021. So I recently published a study with colleagues from the Global Development Policy Center at Boston University, in which we showed that nearly 1/5 of all the upstream oil and gas developments that would need to be canceled if the world actually followed this energy transition pathway are protected by investment treaties. And the ECT was protecting more of these investments than any other treaty. As such, an immediate removal of protection for fossil fuel investments under the ECT would be a big deal. But that isn't what we get in the Modernization Agreement. So first, we get a cutoff for protection of new investments from August of next year. So that's more than 2.5 years behind the IEA schedule, which means a whole lot of 1.5 degree incompatible assets will continue to receive protection, including some potentially big ones. So for example, just to throw out one possibility, the UK government is currently considering giving the go-ahead for the development of the Rosebank oil field, which is the biggest undeveloped oil field in the North Sea. The emissions from burning the oil and gas from Rosebank would be more than the annual emissions of the 28 lowest income countries combined. The project is led by Equinor, which is a majority-owned Norwegian, state-owned Norwegian company. Now, Norway is not part of the ECT, but Equinor does have a subsidiary in the Netherlands that it could use to access protection of the treaty if the project is approved prior to August 2023. So in addition to that deadline of next year for new investments, there's also this 10-year phase out for existing investments, but we actually don't know when that will start because it depends when the Modernized Agreement is ratified. And we actually could have protections for fossil fuel projects lasting until 2040. That is way, way too late. Now you might ask, why do we need to do anything about existing oil and gas when the IEA focused on canceling new projects? So very briefly, I would just say the IEA's pathway it's better than their previous ones, but it's still based on a lot of speculation about future technologies. And the latest science, which was published in environmental research letters earlier this year, suggests that we actually need to retire existing projects early in addition to halting new developments. On the question of whether ECT parties could have negotiated a sooner deadline for phasing out fossil fuel protection, I do think it's worth recalling that when NAFTA was modernized, absolutely all investment protection between Canada and the US was phased out in only 3 years. So as of next July, no fossil fuel investments in Canada or the US will be protected by the USMCA. That is still arguably too long because it gave TC Energy the opportunity to sue the US over the cancellation of the Keystone XL pipeline. But still, I think we can all agree that 3 years is much better than 10 plus. So that's the too late part of the story. What about too little? That's pretty simple. The ECT will still protect fossil fuels indefinitely because so far it only seems that the EU, UK, and Switzerland want to use the option to exclude them. And even worse, if the ECT continues to exist, then the efforts to expand it, particularly into oil and gas rich African countries, will continue, and this will massively increase the carbon footprint of the agreement. So in my view, the UK and the EU can't credibly claim that the modernized ECT is compatible with the Paris Agreement just because they have made efforts to protect themselves from investor claims. Climate change is a global issue and we need action everywhere, and most countries in the world have far less capacity to deal with ISDS cases than Europe does. So in these brief comments, I've just mainly addressed upstream oil and gas, but I do want to encourage everyone to also read the briefing that was just released a few days ago by E3G. I'll put a link in the chat in a moment. It goes into more depth on gas power, coal power, pipelines, hydrogen, and so forth. And there are a number of dangerous exceptions and loopholes in the fossil fuel carve-out that people should also be aware of. So I hope that's under 5 minutes. Thanks so much.
Oh, that was perfect, Kela. It was a very clear answer and a very great overview to start with. I will now turn with Nikki. Hi, Nikki. You are the director of the Climate and Energy Program at CL, and you have extensive legal experience in human rights and environmental issues, and notably on climate justice. And I would like to know a little bit also about the other major reform of the ECT. We have been talking about the exclusion of the fossil fuel investments, but the new ECT also adds a number of new energy materials and products to its scope. So from your perspective, could you perhaps explain a bit whether those are supportive of the energy transition and whether these are actually needed to meet the objectives of the Paris Agreement?
Sure, and thank you. Thanks so much again to the organizers for pulling this event together, and it's a pleasure to be here. So I too will start with a short answer, and I think the short answer to that question is no. Extending protections as the new ECT does to carbon capture and storage, hydrogen, ammonia, methanol, and others, those are the new energy activities and materials and products on which I'll focus, does not support the energy transition or help keep 1.5 degrees alive. And let me unpack why. You know, as Kyla was just saying, what is needed to meet the objectives of the Paris Agreement, or the keeping temperature rise to 1.5 degrees and more fundamentally avoiding catastrophic levels of warming, is rapidly ending reliance on fossil fuels. And that means halting all new investments, all expansion in oil, gas, and coal, and immediately phasing out, that is retiring and accelerating the shutdown of existing fossil fuel facilities. And not only is that implicit in the studies that Kyla referred to, but the latest IPCC report published this year made that very clear, emphasizing that without early retirements or reductions in utilization, the current fossil fuel infrastructure will emit more greenhouse gases than is compatible with 1.5 degrees. It also showed that reduction in phase out is possible through accelerated renewables and energy demand reduction. But carbon capture, hydrogen, ammonia, and methanol do not accelerate the phase out of fossil fuels in any way, and in fact, entrench reliance on fossil fuels, particularly fossil gas, because they themselves are dependent on fossil fuels directly or indirectly, and are promoted by the fossil fuel industry, both as a new source of demand for its products and as a way to offset or justify ongoing oil, gas, and coal production. So the risks of bringing these technologies into the ECT are really threefold. One, as I've said, because they are deeply linked to fossil fuels and particularly fossil gas, protecting investments in these technologies may in effect extend protection to their fossil fuel inputs or supplies. And I'll get into that in just a minute. Secondly, because they carry significant risks, all of these technologies that aren't yet adequately regulated and which states need to be able to respond to as their development and deployment proceeds. And protecting investments may in fact tie the hands of states to do so. And also investment protections could lock in incentives and subsidies provided to these technologies, even if they later prove to be ineffective from a climate or energy perspective, as they have been shown to date. You know, first, let me turn to the way they serve as a backdoor extension of protection. So take CCS, carbon capture and storage. It's literally parasitic on fossil fuel burning facilities. Its function is to keep those facilities operating longer on the premise and promise of reducing their carbon dioxide emissions. But in fact, in practice, we've seen that CCS has repeatedly overpromised and underdelivered on the ability to capture emissions, and instead locks in place facilities that should otherwise be shut down or replaced. And not only that, but we also have seen that CCS, when it is used, captured carbon is used to pump more oil out of the ground through enhanced oil recovery, feeds into the perpetuation of fossil fuel production and use. Hydrogen and ammonia similarly are both heavily reliant on fossil fuels and specifically fossil gas. Over 98% of hydrogen currently produced is made from steam reforming fossil fuels, predominantly methane. And ammonia, which is made of hydrogen itself, is similarly reliant on fossil gas and a huge user of fossil gas, not only as an input, a chemical input, but a power source for those energy intensive processes. So these energy materials and products actually are users of and entrenchers of reliance on fossil fuels. And so by protecting them, it's actually potentially extending protection to investment in and reliance on those fossil fuel sources, as investors could push back on measures that seek to that change their access to those supplies and inputs. And just to turn to the other two features of the risk that extending these protections poses. As I said, each of these technologies carries environmental health and safety risks, some of which remain really poorly understood and underregulated to date, from the safety of transportation, of storage and compressed carbon dioxide and hydrogen, to liability for storage in the long term, and the safety of chemicals used in the capture processes. But by locking in protections for those investments now, it ties the hands of states to actually evolve the regulatory framework to safeguard against those risks and to impose stringent requirements. And finally, investment protections could lock in incentives and subsidies that are provided to these technologies, even if they prove to be ineffective in achieving energy and climate objectives. And we've really seen that already in practice. If you look at many of the experience with some of the subsidies for carbon capture and hydrogen in place to date. So creating these investment protections risks being really a backdoor way to lock in fossil fuels at precisely the moment when fossil fuels need to be phased out and when pressure is mounting to do just that.
Thank you very much, Nikki, again, for a very clear answer to my question. Now I would like to turn to Lucas, who's an international law analyst at ISD and also a PhD researcher, and your work focuses on investment law and policy, and you've been very closely following the negotiation of the ECT. So I would like to ask you a question that relates to a third aspect also of the reform that was very much promoted by the European Commission, because one of the problematic aspects of the ECT is clearly the very vague language of the investment protection standards that have allowed and still allows investors to challenge legitimate public policies. And the ECT reforms were notably aiming at removing most problematic aspects of these investment protection standards, but also to introduce new safeguards to preserve states' regulatory space. So ISD has published also an analysis of the ECT back in July of the agreement in principle, but now with the leaked text, could you perhaps also share your assessment that was leaked last week?
Yes, thank you, of course, Amandine. So our overall assessment is that the standards in the newly leaked text remain vague, and that the draft text is clearly out of step with recent treaty practice when it comes to investment protection and regulatory space. I'm going to try and demonstrate this by considering the provisions on fair and equitable treatment, indirect expropriation, the right to regulate, as well as the new articles on damages and third-party funding. So first of all, the reform of the provision on fair and equitable treatment, or FET, is crucial because it is the most widely relied on substantive standard of protection in ISDS in general, and has successfully been claimed in numerous ECT-based cases. The article on FET in the draft text contains a closed list of elements defining which measures violate the standard. Importantly, the frustration of an investor's so-called legitimate expectations is expressly included in this list as a standalone ground for breach of FET. The concept of legitimate expectations is widely criticized for its vagueness and has led to an entirely incoherent body of arbitral jurisprudence. The fact that it has now been included as a standalone ground is clearly out of step with recent treaty practice, including the EU-Singapore IPA, CETA, and the EU-Vietnam IPA, which all provide that legitimate expectations are but one factor that may be taken into account when determining the existence of a breach. Some major other recent treaties, such as the CPTPP and the United States, Mexico, and Canada Agreement, even exclude legitimate expectations as a ground for breach of FET altogether. So while the draft text tries to circumscribe and somewhat rein in the concept in a footnote, this is nowhere near sufficient to prevent a broad construction by arbitral tribunals. As it stands, the standard will therefore continue to generate a considerable risk for states. Another standard that is vague and with uncertain added value is the protection against indirect expropriation. Arbitral tribunals have interpreted the standard to cover situations where a state takes effective control of or otherwise interferes with the use, enjoyment, or benefit of an investment, depreciating its economic value, even without a direct taking of property. So you can see that the definition of this concept is already vague and grants broad discretion to arbitral tribunals. At the same time, arbitral tribunals have been reluctant to consider the intent of the host state in adopting the measure in question. And as you can imagine, that is particularly relevant for climate policy. The provision is the second most widely invoked substantive protection standard in ECT arbitration. Its reform is therefore crucial. Where indirect expropriation is included, the precise formulation of carve-outs for regulatory measures relating to climate change and other matters of public policy is vital. And the draft text now requires that the measures be non-discriminatory, however, without further specifying what this actually means. And this is particularly problematic because in case of early shutdowns of fossil fuel projects, measures will likely to be targeted at specific fuels or even individual projects. Arbitral tribunals might therefore well consider such targeted measures to be discriminatory. And what is particularly regretful, the new text states that measures that are designed and applied to protect legitimate policy objectives, such as the environment, may nevertheless amount to indirect expropriation in some circumstances. So besides FET and indirect expropriation, the draft text also includes a provision on the right to regulate. While we welcome this inclusion, it does not obviate the need for more carefully circumscribed protection standards. In any event, the right to regulate is a sovereign prerogative that exists regardless of its express inclusion in a treaty text. And a general reassertion of that right will not safeguard against overly broad substantive protections. In addition, the draft text contains GATT-style general exceptions. However, those exceptions will not be applicable to the expropriation provision. And more importantly, the language of the exceptions does not react to recent and problematic arbitral jurisprudence, such as the highly criticized interpretation of the exceptions by the tribunal in Eco Oro and Colombia. And finally, on the issue of damages and third-party funding. The provision on damages is a reaction to concerns about steeply increasing amounts of compensation that are being awarded by arbitral tribunals. In our view, the new provision deals with several non-issues while failing to address the main problem, which is the use of forward-looking valuation techniques. These techniques, like the so-called discounted cash flow method, allow tribunals to calculate damages taking into account hypothetical future income streams over the entire projected life cycle of an investment. And with fossil fuel investments, where the underlying price development can be particularly volatile, you can imagine that this can generate a real risk of liability. Moreover, in our view, the new provision on third-party funding is mere window dressing. The practice of third-party funding in investment arbitration claims is neither restricted nor prohibited. The provision merely requires disclosure of the identity of the funder, but crucially fails to require publication of the funding agreement itself. And finally, there are no sanctions for non-compliance, effectively rendering the provision moot. And as you already indicated, we have also published an extensive legal analysis of the ECT Agreement in principle in August, and an updated version taking into account the recent leak will be published shortly. And I'll put a link to the previous version on the chat now. And with that, I hand back to you, Amandine.
Thank you very much, Lucas. And I think we are all very looking forward to reading your updated analysis. And now, Christina, welcome. You are professor of EU law at the University of Amsterdam, and you are also director of the Amsterdam Center for European Law. And you have published extensively on EU constitutional issue, EU external action, and also separation of powers within the EU. So I definitely have some burning questions in that regard on the process, also in relation to the potential provisional application of the ECT. But I think I will first ask you a more general questions after the presentation of the different speakers that we just heard, because the member states are currently assessing the Commission results in the negotiation and whether they fulfilled also the mandate that was given to the Commission. So there was a twofold objective in that mandate, where it was to address EU law incompatibility issues and also to align with EU climate objective. So from your perspective, do you think that the Commission has achieved this twofold objective?
Many thanks, Amandine. I'm also very happy to be here, and thank you for organizing this. Let me start by the EU compatibility, in the sense that we have, of course, had the judgments of the European Court of Justice prohibiting intra-EU arbitration. In principle, already in 2018 in Achmea, many people would argue, but certainly and specifically with regards to the Energy Charter Treaty in 2021 in the Comstroy judgment. So one aim was to avoid the place that member states landed when they were sued under the Energy Charter Treaty, namely between EU law and the awards that could potentially be granted by arbitration tribunals. And I think on that point, the new modernized Energy Charter Treaty fares reasonably well. We do have an RIO clause, so we have a clause specifically addressing regional economic integration organizations, which is in essence the EU, saying that the ISDS clause does not apply. So specifically referring to our Article 26 in the Energy Charter Treaty. So that means, and that has changed the situation, that arbitral tribunals should no longer hand out awards in intra-EU arbitration. And that was different before. Before we had the situation that, yes, it was against EU law, but the expectation, also the practice largely with few exceptions, was that arbitral tribunals would nonetheless rule on intra-EU arbitration and simply regard EU law as irrelevant to the question of jurisdiction under the Energy Charter Treaty. So that has been addressed. And the greatest, before what was considered, if you like, a loophole was that after the rulings of the Court of Justice, national courts of the member states were nonetheless prohibited from enforcing awards given in intra-EU arbitration, but there was always the possibility, hence loophole, to move to national courts in non-EU states. So since we now hopefully no longer would have new awards in intra-EU arbitration, that is no longer an issue. What of course remains a potential problem in any event is the restructuring of companies, so that companies who earlier were intra-EU, so hence investors from one of the EU member states, would restructure their company structure in a way that they become non-EU investors. And that is something that the modernized Energy Charter Treaty aims to address. So it has a provision on how we should understand the seat of a company, and it says that the company must have substantial business activities in the area of that contracting party, so the contracting party under which law it is constituted. So there is an attempt to avoid that. If we assume that this is reasonably applied, it should at least address part of that loophole. However, multinational companies often have substantial activity in many countries. So it's not that easy. It is not that a country then simply becomes a mailbox company in a non-EU state, but often has substantial business in that country. I mean, it doesn't hence address this loophole fully. But still, I would score the addressing of the question of compatibility with EU law in light of the Comstroy and Achmea rulings still considerably high. I mean, depending ultimately on the interpretation of this new Article 1, paragraph 7 of the Modernized Energy Charter Treaty, saying that you need substantive activity, the question of how willing are companies to restructure their company and to constitute their company seat under a new jurisdiction. These are practical questions that we would need to see happening. But I don't, how shall I say? I mean, every legal provision has possibilities to circumvent it. So I still think that this is reasonably well done. The problem comes more with another aspect that I want to highlight, and that relates to Luca's presentation. And that is, he spoke about the legitimate expectations and the problem of uncertain future profits that are protected. I just want to highlight that this is absolutely not necessary under EU law or the ECHR. So we have actually a judgment of the Strasbourg court saying exactly the opposite from 2018, namely that a company should not have right to uncertain future profits if there's a change in legislation and if the reason for changing the legal provision is a legitimate objective, so hence serving a public good, which it accepted to be compliance with EU law and environmental protection. So it would certainly one could assume that climate mitigation measures would also meet that that criterion. And the second part being that the company could have reasonably foreseen these changes because of the environmental protection measures under EU law. Again, we could say that investors in fossil fuel industries should reasonably be able to foresee that their investments might become under pressure under climate mitigation measures. So does the Modernized Energy Charter Treaty meet the EU's climate objectives? Well, first I want to place a footnote to that question, and that is that we are, of course, absolutely uncertain whether the EU's climate objectives of reducing 55% of its emissions in 2030 as compared to 1990 on its territory, and the fact that it wants to be net zero in 2050, actually meet what is necessary, actually meet what they have committed to repeatedly under the UNFCCC and in the COPs following. And particularly again, and just highlight that in Glasgow, saying that we must stay below 1.5 degrees. So the first question is, of course, do we find it satisfactory if the Energy Charter Treaty meets the EU policy objectives as they are stated today? And in that sense, Lucas has already mentioned some of the aspects in the Modernized Energy Charter Treaty where at least language has been amended in a way that we say that climate change is put in there. But he has also, I think, very convincingly argued why that is too wide and open to interpretation. So I was going to give the Commission a bit by mentioning these linguistic changes, but I think you have already done that and then shut them down. So the only thing I would like to say maybe is 4 reasons why the Modernized Energy Charter Treaty is not sufficient. And the first is that it continues this framework of prioritizing economic goals above the necessary climate policies. And we see that in many aspects. And what I want to add here is that the European Commission really has made a turn to a just green transition. So considering the social consequences of climate mitigation measures. And in that context, we can seriously ask ourselves whether a treaty that protects investment and future uncertain profits from that investment of the fossil fuel industry above and beyond what ordinary property rights are protected, as I mentioned before, is just in light of the fact that an increasing number of people can't foot their energy bills in Europe. So we have a serious problem of social injustice here. And the question is that in line with a just green transition? And I would say no. The second point is, the time periods. We have already heard from Kyla that it's too little too late. And in the aspect of too late, I just want to emphasize one point, that we hear in the debate that the 10-year period starts running with provisional application. And that is, of course, not true, because provisional application is not provisional entry into force. So we must add to these 10 years the time that it takes to ratify the Modernized Energy Charter Treaty by all the parties, which is expected to add years to it, and also means an individual country can keep it hostage. So an individual country that doesn't ratify keeps the entry into force of the 10 years period hostage. And we can see that actually in the text, because the text refers to at the latest in December 2040. Well, then we are, of course, way beyond the 55% reduction of 2030. So, these are questions that I can't answer. I don't know how long ratification will take, but I think it's important to emphasize that there are unknowns still in these 10-year periods. And thirdly, I think what one should emphasize is that the EU is committed to reduce 55% of its emissions on its territory, but that has nothing to do with investments that are placed outside of the European Union. And under the Energy Charter Treaty, as we have also already heard, there are numerous countries that have no carve-outs, that have no intention to limit the protection of fossil fuel in the same way as the European Union does, which means that when EU member states or the EU invests, or EU member states or investors from the EU member states, from the European Union, invest in countries, for example, like Azerbaijan, mentioned as a reliable and trusted energy partner in the communication, then these investments will continue to be protected. But the point is, of course, if you consider climate change a global problem, we must wonder why the EU only commits to reducing emissions on its territory, or not rather emissions that are linked to investors from its territory. And finally, and then I will stop, the question that presents itself is the extension to renewable energy and the extension to carbon dioxide removal techniques under the Modernized Energy Charter Treaty. The question is, to what extent is that desirable? And here again, I would say that cannot be desirable, also not by the European Union, because if we look at EU legislation, for example, the 10E, so the guidelines for trans-European energy infrastructure regulation, then the question is that tries to adapt itself to the rapidly changing technology. And that means that we must remain able to address new technological changes, new technological insights, and we should exactly not protect investment in renewable energy or carbon dioxide removal that we consider desirable today, but maybe in 10 years' time stand us in the way. And the most striking example maybe is the generation of electricity by biomass, which at some point was considered really the future, but no longer. So do we want to protect these investments into the future? And I don't think that's desirable, and I don't think it's in line with what the European Union does internally. Thank you.
Thank you, Christina. And again, thank you, all of you, because I think you very well responded to the question of the desirability and the necessity of the ECT and even the reform that are proposed. I would like to perhaps get a little bit into the details on the process, because I think a lot of persons in the audience are also interested in these aspects. Besides really the content of the reform, there are also indeed these concerns about the lengthy process of for the ratification before the new ECT can actually kick in and enter into force. So perhaps I will turn to Lucas, but also to Christina, to answer some questions on the potential provisional application for the new ECT, notably under public international law, but also any limitation under EU law. So perhaps I will first give you the floor, Lucas, and Christina, we also would like to hear your thoughts on this.
Yes, thanks a lot, Amandine. And maybe just quickly, briefly, before we enter into the discussion on provisional application, I can recall the rules that would actually concern the entry into force and the adoption of the treaty first. So in order to be adopted, the treaty has to, well, there needs to be a unanimous vote at the Energy Charter Conference, probably the one in November, on November 22nd. Unanimous vote of all contracting parties present and voting. That means that, at least hypothetically, if we have 50 plus contracting parties that are present and voting, none of these contracting parties can veto the modernization, or the modernization fails. So that's the first step, and that only concerns the adoption of the proposed amendments. Then in a second step, in order to enter into force, these proposed amendments that have been adopted unanimously would then need to be ratified by 3/4 of all contracting parties. And even upon ratification of these 3/4 by these 3/4 of all contracting parties, it would only enter into force among those ratifying, meaning that the remaining quarter of contracting parties that has not ratified would maintain the old version of the ECT. So that said, let me now turn to the question of a possible provisional application, and I'll focus on the rules that are applicable to provisional application under public international law. So my reading basically follows the one of Christina, that provisional application does not normally mean entry into force. And that is obviously crucial for the UK and EU fossil fuel carve-outs contained in an annex, because they require entry into force of the annex in order to start counting. So the 10 years of additional protection for existing fossil fuel investment only starts running from the time that the annex actually enters into force. The treaty is silent on entry into force of annexes so far. A new article has been introduced, but that will itself only enter into force upon, ratification of 3/4 of all by 3/4 of all contracting parties. So it is unclear. The situation under public international law is also unclear, according to Article 25 of the Vienna Convention on the Law of the Treaties, which does not reflect all contemporary practice. Provisional application of a treaty can happen in either of two ways. One is if the state or states so provide in the agreement itself. For example, CETA provided for provisional application in the agreement itself, or if the negotiating states have somehow separately agreed on it. The ECT does not contain such rules regarding the provisional application of the new amendments and modifications. And if there is provisional application of these amendments and modifications, then there must be a separate document that we haven't seen so far. And at that point, I would like to highlight that for the purpose of transparency and for the discussion, it would be vital to have access to that document in order to be able to actually assess the climate impact of that reform. Then the ILC recently offered a clarification on the situation of provisional application under public international law by publishing its draft guidelines on provisional application of treaties. And it states that there's a presumption that provisional application creates a legally binding obligation to apply the treaty in good faith. Whether that amounts to entry into force is unclear. A breach of a provisionally applied treaty would normally constitute an internationally wrongful act. And unless an agreement on provisional application provides otherwise, it can be terminated at any time, even before the entry into force of the treaty itself, which obviously in the context of the ECT raises the question, what happens if some contracting parties provisionally apply and then stop provisionally applying the treaty before it actually enters into force? And what will the impact of such a situation be on the 10 years of additional fossil fuel protection? A similar question is, what happens if some contracting parties start to provisionally apply the treaty at one time and other contracting parties at another time? So will we see different periods of continued protection of existing fossil fuel investments in the future? Another question that is unclear is, what is the extraterritorial effect of provisional application? So for example, if the EU and its member states provisionally apply the treaty, including the annex that contains the fossil fuel carve-out of the EU, will that actually bind investors from non-EU ECT contracting parties? So in the case of the ECT, unless there is an agreement to the contrary, a contracting state provisionally applying the amendments might well never ratify and just decide to end provisional application. And at that case, the old version of the ECT would apply again with respect to that state. So importantly, a state cannot invoke provisions of its internal law to avoid obligations arising under provisional application. And where a state claims that it did not consent to provisional application, for example, because the EU accepted provisional application of provisions that do not fall under its exclusive competence, such a claim must be based on a manifest violation of the rules regarding competence and must concern a rule of fundamental importance. So the EU member states have a vital interest to clarify before the 22nd November conference what the Commission is actually planning in that regard, and whether it is planning to provisionally apply the treaty and which parts. So in any event, many questions remain open. Will it trigger the deadlines for the protection of existing investment? Which safeguards will, if there is an agreement on provisional application that is separate from the draft text, which safeguards does it contain to ensure that arbitral tribunals would actually construe it in the way it was intended?
Thank you, Lucas. And perhaps for you, Christina, more questions related on that, given also that, for example, in the context of CETA, the investment chapter was not provisionally applied by the EU and the member states. So what does that mean exactly for also the possibility of the EU and the member states to provisionally apply the entirety of the new ECT?
Yes, thank you. Yeah, I mean, first of all, provisional application. I mean, if one entity on the international plane is the expert in provisional application, we should say that's the European Union. Huh? What is the exception for other international actors? It's the rule for the European Union. We even have a provision on that. So 218, paragraph 5 of the TFEU. And what should be emphasized here, and that relates to your question, Amandine, is that in principle, only the provisions that fall under the competence of the European Union can provisionally be applied. But what can, of course, happen is then that the member states, each and every member state, authorizes the EU to, authorizes provisional application individually for the competences that still fall on the member states. And we should, of course, in that context, recall that the EU is competent in principle for direct investment, so that is what we would be looking at here, but that member states, ISDS remains, well, shared, not in the sense of EU terminology shared, but the competence where both must agree to is the common reading of Opinion 215. So who is competent over ISDS? That is both the EU and the member states must agree, because it removes disputes from the national jurisdictions. And for that reason, one would need agreement of each and every member state to provisionally apply the investor state dispute settlement elements of the Energy Charter Treaty. Having said that, that is something that is possible and can happen, so it's not an absolute limit. Another aspect maybe to consider is that Article 218, paragraph 5 does not necessarily require the consent of the European Parliament, so there's no legal obligation to win the European Parliament's consent before provisionally applying an international agreement. However, that is practice, and one should also expect that. And one must read that also in light of the European Parliament's resolution of June 2022, which was very, very critical of the Energy Charter Treaty, and in essence said that it calls on the Commission and the member states to preparing a coordinated exit if the modernized Energy Charter Treaty does not meet the conditions of being in line with the Paris Agreement, and immediately prohibiting fossil fuel investors from suing contracting parties for pursuing policies to phase out fossil fuels in line with their commitments under the Paris Agreement. So if we now take Lucas, Kyla's and Nikki's analysis seriously, we could say that there are serious concerns that the Modernized Energy Charter Treaty does not meet these objectives, so that the European Parliament, at least pursuant to its own resolution, should not consent to provisional applying or concluding the Modernized Energy Charter Treaty as it is proposed. However, that resolution predates the at least published agreement in principle by 1 day. So it doesn't take it into account in its text in any event. But it raises potential problems in the process.
Thank you, Christina. That also would mean, I guess, an important change in the way trade policy and decision-making also are made if the member states would be to give up their competence in the, to the EU on that. So that's also an interesting change. I see questions in the Q&A that I think perhaps is for Kyla. The Commission says that the inclusion of climate objectives in the text of the Modernized Agreement means that arbitrators will be enabled to ignore the policy context of decisions that are litigated. Can you say a bit more about why you don't think this is true or relevant? And I think perhaps that could be also linked to the Rockefeller case, and also what that means for the climate policies, what are the implications, and also perhaps whether that kind of case could actually happen under the new ECT.
Yeah, that's a really great question. I would point out, first of all, that arbitrators are not at all experts on climate policy. But even if they were, there's so much dispute about the best way to address climate change. People who go very much on the, we should just price carbon, and those that are sort of more in favor of also addressing the issue of supply and cutting off fossil fuels. I think it's indisputable that that we need to address the issue of fossil fuels, but saying that is universally accepted as the most appropriate climate policy, I don't think is there. So are we going to let arbitrators decide what is appropriate climate policy? I don't think that's a good path to take. And again, we have all these cases where we have, like Lucas mentioned about like Eco-Oro, where there is an exception there that says environmental policy shouldn't be considered to be problematic under the treaty, and arbitrators just decide to ignore it. So it's very dangerous. The type of policies that I've focused on in my most recent work is very much this kind of blunt, direct cancellation of oil and gas projects that we see in the Rockhopper case. That was a ban on offshore oil within 12 nautical miles of the coast. And this is exactly what we need under the IEA pathway, because they basically said any projects that don't yet have a final investment decision should not go ahead. The problem is there's a lot of projects that don't have a final investment decision, which is made by the company, but they still already have some government approvals. So they have things like an exploration permit. They might have some kind of environmental impact assessment approvals. And investors very much treat that as if they find a commercial deposit, that means that they have a legitimate expectation that they're going to be able to go forward and extract the oil or gas or coal. So I think under the modernized agreement, they will still be able to make those arguments, regardless of any wording about climate policy, or we have other treaties that have sustainable development in the preamble and so forth. I think that all gets sort of easily dismissed. And my concern also extends outside of what actually happens in arbitration. I worry about regulatory chill. And I think cases like Rockhopper will have a chilling effect, particularly in countries that have much less capacity to deal with investor-state disputes. We already have some evidence that countries like New Zealand have said that they didn't go as aggressive on phasing out fossil fuel production because they were concerned about ISDS cases arising. So I think we should all remember that this regime has impacts beyond what it is just decided in an arbitration. Also, arbitration cases take many years, as Rockhopper did. So everyone's sort of sitting around many years wondering whether that kind of policy is going to be accepted. And now we know that, at least for that tribunal, it was not. Thanks.
Thank you very much, Kayla. And looking also at the questions in the Q&A, I think more generally, perhaps that is for you, Nikki. Perhaps, I mean, one thing that hasn't been considered yet by the Commission is clearly the question of withdrawal. So we are discussing the new ECT and adoption of the new ECT, but we are not also discussing what would be the main benefits of the EU leaving the treaty. So perhaps you can have a few words on this.
Sure. I mean, I think that other speakers have made abundantly clear what follows from this analysis is that the protections afforded under the existing ECT and those that are actually maintained and in some cases extended for indefinite periods under the modernized ECT are incompatible with existing obligations under international human rights and environmental law. And arguably, it doesn't matter what provisions are included in a modernized treaty recognizing the right to regulate, for example, or I would argue the existing duty to regulate, because that obligation exists under international law now and is being disregarded systematically by ad hoc tribunals that are not bound by precedent and then have divergent approaches to interpreting the primacy of international human rights and environmental law or public interest law over enhanced property protections, as Christina has said. So I think that the advantages of withdrawing from this agreement are to actually end and begin focusing on how to manage and decide in terms of agreements inter se and through other provisions, how to justify the non-application of the sunset clause, whether that is under enhanced arguments regarding fundamental change of circumstances, or whether that is under understanding what options are on the table for the annulment or extinguishment of the application of that clause inter se between states that agree to do so, and that by actually declining to ratify this modernized treaty and moving towards withdrawal, this focuses, it actually shows a recognition on the part of states that there is this incompatibility, whereas I think in agreeing to this modernization and the carve-outs that are deficient that are there would actually tie those states' hands in arguing if they were to pursue agreements inter se to carve back and to peel back the application of the ISDS provisions in the treaty between each other, because it would demonstrate a sort of commitment and state practice towards extending protections for defined periods of time that, as we've heard, may well exceed the supposed 1 year for new investments and 10 years for existing investments. I also just want to emphasize that it should not, we often get caught in the technicalities and the details and feel that states are bound and really handcuffed by this system. But a fundamental point is that The ISDS system was created by states and it can be dismantled by states. International law is made and unmade all the time. And that is, precisely within the power and purview of states when they are cognizant of their competing obligations under extant law. And when we see the kinds of gigantic loopholes that have been built into even the carve-outs that the EU and the UK have stipulated, these loopholes that really are gas plant and pipeline size loopholes that invite a continued investment in fossil gas going forward. It's clear that tinkering with this instrument that is fundamentally incompatible with the ability to rapidly evolve policy to meet the mounting and accelerating climate crisis requires a fundamental rethink, and that states shouldn't shy away from managing that withdrawal and accelerating and keeping pressure on that exit strategy.
Thank you, Nikki. And perhaps one last question before I close this panel. I think one of the big concerns is also if the member states are not able to adopt the new ECT, and they may be stuck with the old ECT forever if they cannot also agree to leave the ECT in a coordinated manner. So there seems to be some concerns also on that hand. And I see Lucas and Christina nodding. So perhaps I can give you the floor if you could briefly respond to these questions in the next 5 minutes. That would be very much appreciated. Lucas.
Thanks a lot, Christina. I'll let you also offer your view on this. But just my initial thought is, yes, of course, that there is this possibility of a kind of a deadlock situation. I think in that situation, the best way to go forward would be unilateral withdrawal. And as we have discussed before, the more states unilaterally withdraw, the greater the possibility is also to conclude an inter-se agreement, and that could be an open-ended agreement to neutralize the sunset clause. So that could be an agreement that is open for newly withdrawing states to sign on to accede to, basically. So there is a certain flexibility in this idea of withdrawing. It can be a coordinated withdrawal that happens at the same time, but it could also be a withdrawal that is spread out and doesn't have to happen exactly at the same time, as long as states manage to agree to some extent to conclude an inter-se agreement to neutralize the sunset clause. And obviously, the more states withdraw, the smaller the risk that the remaining ECT would generate in relation to arbitration.
Christina, would you like to add anything to that?
I think that's exactly the analysis, and that's also why, we have heard from Kyla at the very beginning of this session, it is too late. We must move forward. So the problem is that we are in a sort of paralysis, waiting for what the modernized ECT could or should or might mean. And I think that is the problem. We should move forward immediately. So suggestions that member states should only withdraw after the modernized ECT has entered into force in order to at least fall under that legal regime and not under the old ECT is, of course, bound to delay everything. So I personally think that, we should start withdrawing with as many parties as possible, as soon as possible, and then conclude the inter-se agreement to avoid the sunset clause and everything that we can actually eliminate the effects among those that are willing to withdraw. The next point is also what I found very interesting, but I couldn't find it online, is the European Parliament calls on the Commission to publish its study on the impact of withdrawal. So apparently there is a study on the legal impact of withdrawal that I at least couldn't find. And on the 23rd of June, the European Parliament found it necessary to call on the Commission to publish it. So I would be interested in what the evaluation is. And I personally find that at the moment, we have a big silence on that side. We have no engagement with the fact that several member states have voiced, as we have also heard from Susie in the beginning, that they want to leave or even have taken national legislative measures. So clearly, I'm not saying that there's unanimous agreement between member states on what issue would there be unanimous agreement on anything, but there is a push, and there's also public opinion that pushes for it, including, for example, in the UK. So the UK not being an EU member state, but potentially one could convince the EU to join, the UK, I'm sorry, to join?
Thank you very much, Christina, and everyone for this very great discussion. I think it's also set the tone and will trigger more discussion in the second panel, where our colleague Eleanor de Anzizu will moderate also a discussion, a public debate. So I think we will hear more, and we also have time to perhaps also address some of the more policy questions that were asked in the chat. So now I hand it over to you, Eleanor, and thank you, everyone.
Thank you, Amandine, for your excellent moderation. And also thank you, Kyla, Christina, Nikki, and Lucas for your excellent presentations. And welcome all to the second panel of this event, which is a public debate on the climate and energy policy implications of the new ECT. So we have heard from colleagues the legal implications of the new ECT, and now we're going to move into the second part on the energy and climate aspects. My name is Eleanor de Anzizu. I'm an attorney from the Climate and Energy Program of the Center for International Environmental Law. I will be your moderator today. And for this panel, we are thrilled to have with us three excellent speakers, Mr. Brooke Posnick from DG Energy at the European Commission, Mrs. Cornelia Marfield, Senior Trade and Investment Policy Coordinator at Climate Action Network Europe, CAN Europe, and Mr. Rainer Hinrich Rachler, Vice President of the European Renewable Energy Federation and board member of the German Renewable Energy Federation. We will start with a first tour de table, as Amandine did for the first panel. I would introduce each speaker a little bit more and ask each speaker a question. Each of you will have 5 minutes to intervene, and then we will you will have the opportunity as well to intervene again afterwards, and we will open also for Q&A. So in the audience, if you have questions, please bring it on right now. So starting with Mr. Brooke Posnick. Brooke, you have been working for the European Commission since 2018. When you joined DG Energy, you first specialized in just transition and coal phase-out issues, and in particular led the team in charge of the initiative for coal regions in transition in between 2020 and 2022. Since June this year, you have joined the international team of DG Energy, and in that capacity, you have been in the negotiations of the modernization of the Energy Charter Treaty. So we are extremely privileged to have you with us today. We have heard extensively our colleagues about the new ECT, but I think it's very important to hear from you. What role do you think will the new ECT play in the energy transition, if any, and how it will help the objectives of the Paris Agreement? Brooke, up to you. Thank you.
Thank you very much, Eleanor, and thanks for the invitation to speak in this panel and in this event. So you're asking about the role of the modernized ECT in the energy transition and on the delivery of our Paris goals. I guess the question's a bit provocative after the 3 or 4 interventions we heard before, but I nonetheless think that it is a very, very good question, a key question, one that has been guiding the European Commission throughout the modernization negotiations. Which I'll try to answer, let's say, maybe from a different angle, less of an angle, you know, of a researcher, you know, looking at the theory, at the different aspects that were mentioned so far, but maybe more anchored in also the reality of the negotiations, which was what I was involved in, and I think would be also an interesting insight for the group. So maybe just to start, indeed, what does it mean to achieve our Paris Agreement objectives? I think that's the starting point. From the EU side, that means implementing our Green Deal, the way it's been upgraded since the beginning of this crisis, with the crisis we're facing now, the energy crisis we're facing now, with, again, increased ambition as to our decarbonization, ultimate goal to reach climate neutrality by 2050. This is our benchmark. This is not nothing. This is a huge challenge, logistically, financially, humanly. Nonetheless, we know more or less what we have to do. We have a clear trajectory. We know we need to save as much energy as we can. We need to use energy as efficiently as we can. We need to roll out renewables massively. We need to electrify our industry, our transport, and where we cannot, we need to use hydrogen or clean fuels to decarbonize them. In a nutshell, we need to get rid of fossil fuels over the course of the next 3 decades, and to do so, especially in the upcoming decades, especially in the energy sector, that has to be decarbonized, let's say, as a matter of priority as the technology alternatives out there. So in short, what do we need? We need a lot of investments, right? And the ECT is a treaty that is meant to protect energy investments so as to de-risk them, to make it less risky for investors to invest. So in theory, that's a great plus to achieve the Paris Agreement, right? But obviously, the current ECT, what we call internally now the old ECT, even though it is still the current one, it's not fulfilling this role. It has outdated rules. It protects fossil fuels, not mainly, but also fossil fuels. It has been misused compared to its original purpose, right? To the level that it is one of the most litigated treaty in the world, in particular with a lot of intra-EU arbitration, which is against EU law. So clearly a lot to be solved with the modernization. Also to maybe say something that I believe is important to frame this modernization in and anchor it in reality. I mean, we don't really have much of a choice in the sense that we have this infamous sunset clause in the treaty, which means that if we exit it, we have to implement the old unmodernized treaty for 20 more years when it comes to existing investments. We hear sometimes about ways that we could potentially neutralize this sunset clause. Our analysis shows that there are no very legally sound way to do so. And therefore, like, the biggest risk is that if we exit, we are effectively stuck with this old treaty for 20 plus years. And we do not have 20 plus years when it comes to the energy transition and the Paris Agreement. So this is also something that is very clear. So in terms of modernization, maybe a few things we did, maybe the big items. First one, the modernization of the investment protection rules. I'm not going to go into the details because it was already talked about, and that would probably mean, speaking for a very long time. But in any case, the objective was to rebalance them, to make it, like less of a burden for states to be constantly under the threat of litigation, to limit the risk of regulatory chill, which is a real concern. So again, multiple here improvements, references to the Paris Agreement directly in the text of the treaty, to sustainable development, to the right to regulate when it comes to implementing climate action, etc. So in a nutshell, a clear text which incorporates Paris objectives directly in the treaty, and this, all contracting parties have agreed to it. So it would apply if adopted to everyone. I know some of us in this room or in this virtual room don't believe investment protection, especially ISDS, is necessary to attract investments. Some people think the EU especially is attractive enough to investors. We don't completely disagree, only partly, let's say. It's true that most EU countries have enough credentials to attract investments without the need for the ECT, but that's not the case of every single EU country. And that is not the case of every country that is part of the ECT outside the EU. They tell us themselves to us, they need such treaties to attract investments. And they do need to attract investments because they might not have a local or national industry that is so developed when it comes to renewable green technologies. So the new ECT is definitely an important element for them to keep attracting investment and hopefully green investments in line with their own Paris Agreement commitment. One thing that we needed to get rid of that was already mentioned by a previous speaker, Christina, I believe, was the intra-EU arbitration. The EU is a single market. There are judicial remedies for investors in the EU, so there is no need for intra-EU arbitration. It is clear in the EU law, intra-EU arbitration is against EU law. Nonetheless, this was not applied under the old ECT, despite the court decisions. So now we have much more assurances that this will not be applied, because the new treaty includes this idea of non-intra-EU arbitration, black on white in the treaty. So that's something very important we did as well. And when you look at the amount of cases that have been put forward under the ECT, the huge majority of them are intra-EU. And therefore, with this upgrade, we solve a huge big problem in the way that is the most legally sound way possible, by adding it directly in the treaty. And third thing, I think big ticket improvement is the end of protection for fossil fuels. As I said, we need to get rid of fossil fuels to achieve climate neutrality, to achieve our Paris Agreement, and we need to do it fast. This is clear. So for that, you know more or less where we landed in negotiations. I think it was mentioned before. We have a carve-out for the EU and one for the UK. I'll talk about the EU one. No protection for fossil fuels, for new investment in fossil fuels in the EU, applicable almost immediately as of next year. So much further and much faster than if you were exiting from the treaty, for instance. And we have a transition period of 10 years when it comes to existing investment in fossil fuels, which enters into, and this, let's say, this transition period starts kicking in either with entry into force, but also with provisional application. And this was mentioned before in the previous panel. There were some doubts about whether provisional application would indeed trigger the 10 years. It does. So, so we don't have to wait for the entry into force for counting these 10 years vis-a-vis the other contracting parties that also provisionally apply. Initially, we wanted these rules to apply to everyone, but clearly the Energy Charter Treaty crowd was not ready for that. Well, nonetheless, we have a very serious EU carve-out that allows us to implement our policies within the EU without the ECT being an obstacle. And one more thing on this, maybe, once you avoid intra-EU arbitration, you have also a lot of your problems in that respect solved. For instance, I mean, I worked on coal phase-out before, you were mentioning, looking at what happened in the Netherlands or in Germany, where we had arbitration cases against coal phase-out measures. These measures were put forward by EU investors. So in the new treaty, they would not have been able to submit a claim. So the final outcome of this modernized treaty is that all contracting parties agreed to reform the investment protection rules, to establish the Paris Agreement and climate action within the treaty, to exclude intra-EU arbitration, and to allow the EU and the UK, so arguably when you look at the crowd of the ECT, the two parties that need to phase out fossil fuels, the first ones, well, to do so. So in my view, not all bad. But the ECT now becomes, you know, what it is supposed to be. So a treaty that incentivizes investments, especially green investments, and that is not an obstacle for us to implement the Paris Agreement. Maybe just one last point. I'm sorry I'm a bit long, but I just wanted to make one last point. Obviously, it is not perfect. In our view, this is the furthest we could go within the negotiations, but it is not perfect. Otherwise, we would not be having these conversations. It is not simple. The treaty is complex. We have different rules depending on the place, on the time, on the type of investments. We have rules that apply immediately, others that enter into force at a later stage. We have transition periods. So it is complex. But in all possible aspects, this complex treaty, modernized, leaves us as EU in a much better position than if we withdraw, which the withdrawal, as I said, is for sure not a Paris compatible way. And in addition to that, and that will be my last point, I would say that, you know, staying in the ECT is also a way to keep a foot in the door, if I may say. Because if you leave the ECT, of course, you apply the old treaty for 20 years, but you also do so without having any influence on the organization, on its functioning, on its strategic vision, on its future. There are questions today about letting new countries in after the modernization. There are some interests in Africa, in Asia, and new accessions, they have to be decided at unanimity. If you leave the ECT, you forfeit the right to decide on who can join and who cannot join and under what conditions. So if you leave the ECT, you lose influence, right? You lose influence also on the way the treaty might evolve in the future, on the revision clause that is mentioned in the revised treaty as well. And I believe personally that if we are serious to implement the Paris Agreement and to accelerate the transition worldwide, my feeling is that we do need the influence of entities like the European Union, which is committed and serious about climate action, in the kind of multilateral fora that is dealing with energy, like the Energy Charter. That would be my final word. And thanks a lot for the opportunity to take part in the discussion.
Thank you very much, Björk, for your points and your important remarks, and to bring also some of the realities of the negotiations and the fact that the ECT is complex and the new ECT might not be perfect. And also to hear the important assessment that protections the fact to protect investors under ISDS is not necessarily that important to attract investors, that the EU believes that with the text as it is without ISDS, it can already send a clear message that protection of foreign investment for the green transition is already there, and there's no need for ISDS. I think that's an important takeaway from your presentation. And now moving to our second panelist, Cornelia Marfil. Cornelia, you are the Senior Trade and Investment Policy Coordinator at Climate Action Network Europe, Europe's leading NGO coalition fighting dangerous climate change. For the past 20 years, you have been working as a communicator and policy expert in various civil society organizations, advocating for a fair and sustainable trade system, for example, as the campaign manager of Stop, TIP and CETA Citizen Initiative. And at CAN Europe, you are also working on EU trade and climate policy. So Cornelia, it would be great to hear from you, as you have been working on the ECT also so extensively for a very long time. What is your assessment on the new ECT? I know we have heard already other panelists, but it would be also great to hear from you. Over to you.
Yeah, thank you very much for the invitation to speak here. For us, the reformed ECT remains a major obstacle to climate action. On the one hand, because the achieved reforms are very insufficient, and on the other hand, because in some elements, the reform also makes the ECT more dangerous from a climate perspective. On the insufficiencies first, I mean, the bottom line is that the ECT will continue to be used by fossil fuel companies as states fulfill their obligations towards the Paris Agreement to achieve climate objectives and phase out fossil fuels. This is because, first of all, central aspects of the ECT were not even touched, not changed at all during the reform. This includes the heavily criticized ISDS mechanism, but also the 20-year sunset clause that is so often used as an excuse why countries need to stay in the ECT. It was also totally unchanged in the reform. There were also various missed opportunities and marginal changes with regards to investor rights. A missed opportunity is clearly that the awards continue to be calculated on such a basis that they allow investors to get compensated, not just for the actual investment, but even for future prospective profits. We have just seen in the Rockhopper case that the investor got multiple times what they originally invested, even though they hadn't even started drilling for oil. And all these compensations make the energy transition incredibly expensive, and the reform doesn't change anything about this. Thirdly, the fossil fuel carve-out is very deficient. That was already covered quite well by Kyla Tienhara on the first panel, so I won't repeat, just to say the 10-year period is too long, whether or not it starts counting in August 2023, or whether it only starts when everything is ratified. And I think that remains to be seen, because we do not know whether the provisional application will actually go ahead, whether this is possible from a legal perspective, but also whether member states will actually agree to it. And also, we shouldn't forget that there are really extensive exemptions for new gas investments. So it's not a full fossil fuel carve out. We basically, all of this was designed well before the current energy crisis, well before the current issues that we see in particular with fossil gas. And it is just unbelievable that even though this crisis was ongoing as the negotiations went on, that no change was ever attempted. And this also shows that the European Commission did sometimes really shy away from coming in with new and better proposals, even though they would have been necessary. But then, I mean, we've got these insufficient reforms on the one hand, but what is really worrying and what is hardly talked about in public debate is the fact that there is a massive expansion of investment protection for new technologies. So we're talking about biomass, biogas, ammonia, certain forms of hydrogen, even synthetic fuels. And this expansion is totally unnecessary from the point of view of getting new investments attracted. What I hear you from Priok in his statement about certain EU countries not being attractive enough for investments, well, seriously, I mean, the EU can also do a little bit more for the attractiveness of the member states than expanding an agreement like the ECT, which wouldn't even apply to most of the investments made in certain member states. Many investments, like globally, 75% of renewable energy investments are actually domestic, so they are not protected under agreements such as the ECT. Within the EU, most investments are intra-EU, where even the European Commission is saying they don't apply here. The ECT doesn't apply here. So actually, what kind of share of investment are we talking here? Japan invested in some sort of renewable energy facilities in, I don't know, Romania? I think that's probably a very marginal prospect. Moreover, we have seen that globally, there are a lot of very attractive destinations for renewable energy investments that haven't really signed on to ISDS. So that doesn't seem to be an incredibly important factor for renewable energy investors. I'm talking here about countries like Brazil, one of the countries worldwide that gets the highest share of renewable energy investments and is considered very attractive, but nevertheless has never signed on to any agreement having ISDS. Also, if you look at studies that show the attractiveness of renewable energy investment locations for investors, the existence of investment treaties doesn't feature. So I think we are really overrating the importance of the ECT here when it comes to renewable energy investments, while having a blind eye for all the risks that are associated with such a strategy. So that's basically why this expansion to new technologies is really a very false step in our regard. Also, we are talking about an agreement here, a patient that is really on life support for many years. We have seen countries withdrawing, Italy, Russia, Australia, they have already all left the agreement, and Norway never ratified it, even though they originally signed on to it. And we have several EU member states now openly talking about withdrawal. By signing on to this reform process, the EU would breathe new life into this agreement that is really dangerous from a climate perspective, whereas by withdrawing, it would have the opportunity to actually deal it a death blow. And I think here we also disagree with Preyuk's view. I don't think the EU needs to have some sort of foot in the door of an agreement that doesn't really show any benefits, but rather a lot of risks. It is the EU is the major contributor towards the budget of the Energy Charter, and by withdrawing, it would really make the institution a lot weaker. It would also signal to other countries, particularly in the global south, that they should not become a member of this ailing agreement, which I really hope they will realize. We do not want any countries, in particular in Africa, Asia, or Latin America, to join this agreement. Kyla already mentioned that many of these countries are very rich in oil and in gas reserves, and would basically make it a lot more likely that these investments would also become protected under the ECT. So let's be clear here. We have the choice between breathing new life in an agreement that is already on the brink of dying, or giving it the final push. And from our perspective, this is what should happen. The EU should withdraw, ideally coordinatedly, so that the sunset clause can be neutralized. And this would be by far a better outcome from a climate perspective.
Thank you very much, Cornelia. It's really great to hear from you on the insufficiencies of the new ECT and the fact that it's not a full fossil fuel carve-out, noting the addition as well of the expansion to new technologies, which was also discussed by Nikki previously in panel 1, and also the fact that you contemplated the possibility of withdrawal and the important signal it would send to other countries that are yet not part of the ECT, noting that the Secretariat of the ECT is continuing to try to expand the ECT to new countries, particularly in Africa. And also your points on the attractiveness of foreign investment to countries that actually are not bound by ISDS or the ECT. And on this point, it's great now to move into our next panelist, Mr. Rainer Inch Rafler. I'm sorry, my German is terrible, but I'm trying my best. You are a renewable energy policy expert with more than 20 years of experience. You are the Vice President of the European Renewable Energy Federation, ERF, after having served as the association president from 2010 to 2014. You're also a board member of the German Renewable Energy Federation, BEE, and BEE's Commissioner for European Affairs. And before joining the renewable energy sector, you were the Director General and Deputy State Secretary at the German Federal Ministry for the Environment, Nature, Conservation, and Nuclear Safety. We are privileged to have you with us, Rainer. And the question I would like to ask you now is, how important do you think the flexibility of states to regulate the incentives provided to renewable energy investors will be in the coming years? Thank you. Over to you.
Well, thank you, Eleanor, for having me here, and indeed thanks to the organizers for setting up this very interesting and definitely very important panel. Indeed, let me give first a very short answer to your question and then elaborate a little bit on it. How important is flexibility for member states to develop policies, to implement policies supporting renewables, phasing out fossil fuels? The answer is extremely important, because there is no silver bullet and there are different national circumstances which need to be followed, which need to be integrated in policy planning, in setting up financial programs, in setting up regulatory systems, in designing energy markets, and all these points. And it was already mentioned by most of the speakers that the overarching element which asks for flexibility and speed is the necessity to comply with the commitments of the Paris Agreement and keep global warming below 1.5 degrees. And we all know that different member states have different levels of ambition, different member states have different resources, they have a different history in energy development, etc., etc., etc. Given that all this is true, member states need the possibility to design within a certain framework their support for renewable energy, to accelerate, to develop in different technologies depending on what resources exactly they have. Of course, in the context of the European Union, which is a very important context, which in the past with the Renewable Energies Directive, which is now entering into the third stage with lots of improvements under discussion. But again, we see member states trying to lower these ambition increases. So it's extremely important to coordinate, but on the other hand, to give enough leeway for member states to design policies and frameworks and regulation as they deem necessary to be as fast as possible and as significantly impacting as possible in setting up a renewable energy transformation. And in this context, of course, we see, and those colleagues here who work within the EU and who are within the EU know how difficult it is already to find compromise between the different European member states, between different parliamentary groups. And of course, we also know that there is quite a consolidated legislation, including different rulings by the European Court of Justice on how this development of renewable energy, how this increase of renewable energy, phasing out fossil fuels could be done, should be done. So that I think it's extremely important not to have negative spillovers from out of the EU institutions in this compromise finding, in this pushing each other to higher ambition on renewable energy. And this is where we are in this arbitrational tribunal mechanism, which still is there, which was not even negotiated, as it seems, to get rid of it, which, and we heard this in the first panel by most of the presenters, even though there is quite some language now that in intra-EU cases cannot be addressed by these tribunals, we still talked about and we heard about all these backdoors which are still there and which certainly will cause a problem to member states and to the certainty, by the way, for investors to know if we decide to invest in a certain country which is part of the EU, they never know whether their decision, whether their investment is really protected when it goes into renewable energy and energy efficiency. There may always be cases in front of these arbitral tribunals questioning decisions on, for instance, introducing carbon pricing, for instance, declaring that renewable energy is in overriding public interest when it comes to comparison with other potential aims of environment, economy, etc., etc. So all these necessary decisions, all these necessary compromise findings may really be affected if these arbitrary tribunals are not completely cut out of decision finding and of policy setting in the European Union. In this context, of course, I have two important remarks, I think. One is this argument we need, or some countries think they need this treaty to protect and to attract investment to their country. I think the best way to attract renewable energy investment into a specific country are two things. One is good EU framework, and we're about to even improve what we have. And there is quite some indication that targets will go up, that the regulatory frameworks will improve. So having all this, then of course it's the member states who have to fill this with life, fill this with their concrete regulation. So if some of the countries who nowadays say they need the ECT, if they just moved forward in their own country with more attractive conditions and more certainty for renewable energy and energy efficiency investors, I think this would do much more for moving forward the climate protection agenda and the Paris Agreement. And finally, of course, in difference to some of the speakers, I'm not a legal expert, but I think I'm a policy expert. And from this, I would say there may be, and there definitely are pitfalls, and there are potential traps in this pathway of leaving the ECT in an organized way. But I'm quite sure because the European Union is politically speaking and economically speaking quite an important power in the world. Many of the EU member states are part of the G7. The EU as such is a major economy, and the EU as such plays always quite a constructive role in international climate negotiations. So I'm quite convinced if the EU as such, or the majority of the EU member states withdraw in a coordinated way from this treaty, there will be a way which will be at least practically feasible to definitely end it and to attract more renewable and efficiency investment to the European Union, and thus showing to the world that investment protection for fossil fuel is definitely not the way forward and is no longer needed and maybe lead in a wrong direction. And in this case, I think the EU is strong enough to negotiate this in the way out. So I would encourage the European Union and the member states, including my own member state where I live in. The German government is still hesitating due to coalition issues, whether or not to completely leave it. But I think I never thought I would agree with Poland in an energy question, but they have decided, and they even have to put forward the law to leave the treaty. So why not follow Italy, Poland, and announcements of France and so on. So this is the way. I think let's try to withdraw in a coordinated way. But of course, for me, at least for the time being, and this is my final sentence, I don't think it's an either or. Of course, we must prepare this joint withdrawal from the treaty. But as long as we are in, as long as we are not out, it definitely makes sense to work on all these more or less insufficient but existing detailed changes which are under discussion. And it does not have to be an either or. We prepare the way out, but as long as we are in, we try to move it in the right direction. I think this is my point, and thank you.
Thank you very much, Rainer, for your technical remarks, and also the need to cut out ISDS in the EU. The fact that the best way to attract renewable investment in the EU is a good framework within the EU and not necessarily ISDS. And the fact that because the EU is such a major economy, if the EU withdraws, there will be a way to attract more investment in renewable energy. And we show also to the world that protection to fossil fuel is not the way forward. I also know that Mr. Jan Gerrit from DC Trade is with us in this event. I was really intending to give you the floor for a few minutes, but I'm failing as a moderator to keep us on time. So if you could bring your remarks in the chat. I'm just going to turn very quickly to the three speakers for a 1 minute intervention with one question, and then move it back to Amandine for the closing remarks. So Mr. Bruyck, I have a question first with you, for you. I was wondering if you could give us a bit of an idea, what are the next steps for at the EU level regarding the new ECT? What decisions need to be made before the 22nd of November at the EU level? And then I will move back to Mr. Rainer and Cornelia. Thank you.
Yeah, of course. Thanks, Eleanor. It's fairly simple at this stage before the 22nd of November. This 22nd of November is an Energy Charter Conference where the Modernized Treaty will be put to a vote. And I think Lucas mentioned in the previous panel, this is a vote at unanimity, let's say, when if one contracting party objects, the modernization is abandoned, right? And the old treaty continues as it is. In terms of steps that we have to take internally in the EU, so I think this will reflect the comment that France had made in the chat, saying that they were still assessing their position on it. Basically, for the EU to be able to take part in this vote, we need an EU position. And at this stage, an EU position is defined at this specific stage of the process by a council decision. When we talk about provisional application or ratification, this is when the parliament comes in. But at this stage, when we talk about adoption of this modernized treaty, this is a council position. So basically, before the 22nd of November, the Council needs to decide as to whether the EU should give a well, should object or should confirm the modernized treaty. And this is the only decision that we have to take before the November conference. After that, there is the decision on provisional application. There is the decision, sorry, on ratification. But this comes after, once we know whether there is or not a modernized treaty to provisionally apply and or to ratify.
Can I just ask, Priyok, when will this vote be taken that you're mentioning, the council vote? When is that taking place?
It doesn't depend on the commission, it depends on the council, and I cannot speak for their own calendar, unfortunately. It will take place before the 22nd of November, which means, you know, in the coming weeks or months, basically. So it's a very short time frame, but I don't have a specific date to give you, Cornelia, I'm afraid.
Thank you very much, Birk and Cornelia, also for your question. And actually, well, I want to jump back 1 second to what Mr. Rayner said. I have a question for you, Rayner. If in one sentence you could say something to renewal investors in terms of ISDS and the ECT, what would be your message to them?
Try to avoid being trapped in one of these tribunal cases and make sure you invest in a country where you can really rely on the existing and hopefully promising good renewable supporting policy framework.
Thank you. That's extremely clear, Rayner. And Cornelia, also in a few sentences. So we have heard and we discussed a little bit about the fact that some member states are considering withdrawing from the ECT. Maybe you have a few words about that. What do you think is the situation now? And what do you think could happen in the incoming weeks? Thank you.
Well, I think the next couple of weeks are really decisive to determine the future of the Energy Charter Treaty. As I said, the agreement is really weakened because it has seen a lot of criticism in recent years and actually no defense. I mean, I'm still waiting for someone to actually step up and to say, we need this agreement because it's rather, oh, we need to stay in the agreement because it's still better than leaving and being liable under this 20-year sunset clause. And I think it is important that the member states look very carefully now what has been achieved. We think it's neither in line with what the mandate demanded, and nor is it basically future-proof when we look at the crises that have emerged since this mandate was originally given. So the current energy crisis, the ever more accelerating climate crisis that just mean states have to act more, they have to regulate further in order to navigate these crises. I think this council vote that Priyok mentioned is really a moment where member states can raise a red flag and say, we are not prepared to breathe new life into an agreement that doesn't help us, but rather hinder us in navigating these crises. I think the EU should basically come to the conclusion that reform is insufficient because the alternative is to withdraw, and ideally to withdraw jointly, so that as many countries as possible can neutralize the sunset clause. And this is basically a discussion that the Commission has blocked so far, and I really hope that that will end. Basically, member states have asked very often, please, Commission, can you tell us about the legal implications of withdrawing? Can we actually have a proper debate about that? And from our perspective, this is only possible when member states will vote no in this upcoming council vote. Because if the ECT cannot be reformed, then a withdrawal is inevitable. And at least there has to be a discussion amongst member states whether this withdrawal can happen in a coordinated manner. Basically, we we look towards countries that have been critical in the past. We have already heard from Poland that they want to withdraw. We've heard a very clear public statement by Spain saying they find the results insufficient. We've heard that the German government has set very clear red lines with regards to withdrawal that are not met by the reformed ECT. We've got a motion from the Dutch Parliament saying that the Dutch government should support a coordinated withdrawal. We've heard critical remarks from France, not very much in public in recent days. In any case, the dynamics are there. There is an opportunity now to end this agreement and set a very strong signal to the world that ISDS belongs to the past and we need something a lot better for this time and age.
Thank you, Cornelia. That's extremely clear as well. And I'm going to close now this panel. I thank you very much, Birk, Rainer, and Cornelia, for your presentations and for participating in these debates, which brings so many difficult questions. And I think you have been incredibly good in assessing and discussing the importance of the new ECT and what needs to be done or not done, and having some critical views about that. I'm going to turn it now to Amandine for the closing remarks. Amandine, thank you very much, and over to you.
Thank you, Eleanor, for moderating this panel, and thank you again to the speakers for their very important input today. Thank you to all the speakers, to the keynote, to everybody who was involved also in the preparation and the organization of this webinar. And thank you also for all the people who have attended this important discussion. It's really great to see that a number of you have stayed over the 2 hours of this webinar. Perhaps really a few words to conclude. I think today we've heard a lot of concerns about around the adoption of the new ECT, and concerns also around the withdrawal from the Commission. I think it's definitely not an easy exercise to balance the new ECT against the withdrawal. I think also we have to acknowledge that there is no perfect solution, and that's why it's so important to balance the cost and the benefits for the climate transition over the next critical decades. The next step is for member states to decide whether or not they should adopt the new treaty, and this decision at the next council meeting before the 22nd of November will be of immense importance. So if there is one call I would like to make, is really to make an informed, sound and evidence-based decision, and for that we need more public debate. We need also more transparency. We are 2 months before that vote, and we definitely need to have publicly available the text of the agreement, the assessment of the Commission of the withdrawal. We need the assessment also and more clarity on exactly how the provisional application. Without that, I think any decision will be very difficult to make. Although the speakers today have given a number of reasons that should help member states in their assessment on the desirability and the necessity of the ECT and its reform. So perhaps if I can end on by echoing also what Lisa said in our keynote speech at the very beginning, is that ahead of the next COP, clearly the EU is the one that can take the lead on climate, and for that they should first remove obstacles to their climate ambition, and the ECT is one of them. So perhaps it's really time to think through really what is the cleanest way to remove the negative impacts of the ECT, and so that we can be also able to move forward and build also a new investment governance framework that actually support the energy transition and enable to meet the Paris Agreement objective. So again, thank you everyone. We are going to close the webinar on that note, and we'll definitely try to organize another discussions in the coming months if that's also necessary again.
Thank you very much. Thank you.